So we're back for the second recording for Chapter 7. We are picking up after the initial complaint is filed. It's been served on the defendant and through a summons that requires the defendant to appear in this court and answer the complaint. When it says appear, that doesn't necessarily mean he's got to then go leave and go to the courthouse and appear before the judge. It means that he's got to or she's got to file the answer, or they may file a motion regarding the complaint. We'll talk about that in a minute. If the defendant fails to respond within a certain period of time, the court can enter a default judgment, meaning that they can award the plaintiff what they asked for because the defendant had notice and they didn't file the answer and during the prescribed amount of time. So the defendant hopefully is going to file what's called a responsive pleading. They're going to either file an answer, meaning they're going to admit or deny the allegations in the plaintiff's complaint. They could file a cross complaint saying that, wait a minute, it wasn't me that committed a wrong. It was you. You're the one that ran the stop sign, plaintiff. So I'm filing my own complaint, a cross complaint, or counter complaint. There could be, it could be that, no, it wasn't you, plaintiff, it was this third party, and I'm going to file a cross complaint against them. They can, it can also have what's called an intervention or a consolidation. Some individual who has an interest in the outcome of the case can file to be allowed into the case. Or we could take, the court could decide to take several cases that are related to the same set of facts and consolidate them into one case. So the defendant, let's assume that either they're going to file a traditional answer. They could also file a motion to dismiss saying, okay, court, judge, even if everything that the plaintiff said is true, he still has not stated a cause of action upon which relief could be granted. So please dismiss this case. And if the judge says no, denies that motion, then the defendant is going to be allowed additional time to file their answer. Okay? And that motion to dismiss would also have usually a brief that goes along with it to support why that case should be dismissed. This is the copy of an answer, a traditional basic answer, where all of the numbered parts of the plaintiff's complaint are used again in the defendant's answer, and they're either going to admit or deny. Okay, so what would they admit to? Well, in one of the numbered things could be about jurisdiction. They could say, yes, I agree that this court has jurisdiction. So don't assume that you just deny everything. There are things that you go ahead and admit, and by doing that, by both parties agreeing that that is a fact or that is a true statement, then it's something that does not have to be litigated. We can go ahead and say, okay, that's a fact. Here is the motion to dismiss, saying that the party did not state, the plaintiff did not state a claim upon which a relief could be granted. Once those two pleadings have been filed, then there usually is going to be a scheduling conference or a pretrial conference where both of the attorneys and the judge that's been assigned this case are going to get together and talk about how can we manage this case efficiently. What timelines should we establish for the filing of the filing of discovery and collection of discovery? When do we think we could get on the trial calendar? What types of motions are we going to have, and how are we going to go about you know having those motions heard and rulings made about the motions? Okay, and once we do that, then we usually are going to move into that discovery phase. In the scheduling conference, we have talked about the schedule for discovery. Discovery is where we are going to be obtaining evidence to assist us in trial. It could be paper documents, it could be physical items, it can be physical or mental exams. We'll talk about each of those, but this is where we're going to spend the large majority of the litigation process is spent in discovery. We're going to get what evidence the other party has. We're going to get notice about that. Discovery can lead to settlement. Once we're able to determine what evidence both sides have, it may be a impetus to settle this case and not go to court. It's a way to preserve evidence from witnesses. Maybe a particular witness is very ill and we don't know if they will make it to trial, so we're going to take a deposition to preserve evidence. It helps us to narrow down the issues so that we are not dealing with more than can be addressed at trial. We can get it down to just those things that we truly are in disagreement about. We're going to talk about the different forms of discovery. The first is interrogatories. Now, interrogatories are questions, sets of questions, and we will have determined in that pretrial conference how many sets of questions and what number of questions can be in those sets. But they're written questions that have to be answered in writing, and they are answered under oath. So when a party answers the interrogatory, that is the same as sitting on the bench at trial and testifying. It is under oath. And each side can draft their questions to the opposing side and vice versa. And you have a certain amount of time to respond to those interrogatories to answer those questions. Here is an example of some interrogatories that were sent to the defendant. First question, and you see it's in the same format as the pleadings, as the complaint and the answer. You've got that caption where you've got the courts, who are the parties, and what type of document is this, then you go through the questions. And I know I've expanded it out so it is not real easy to read, but number one, were you the driver of an automobile involved in an accident with the plaintiff on August 4th, 2016 at about 7:45 a.m. at the intersection of Maddie Avenue and 38th Street in Nita City, Nita? If so, please state your name, every name you've used in the past, the dates you used each name, the date and place of your birth, and go through each of those. Now, the attorney is going to be the one handling this document. The plaintiff is not, or the defendant is not just going to take this home, get this at their house and sit down and start answering the questions, because there's some things that, one, we may not want to provide an answer about. There may be things that we don't know the answer to. So you want to get your attorney to complete this, and there are time limits on your responses. The next that we're going to talk about are depositions, and those are where you are going to appear before the other side, and there'll be a court reporter there, and the attorney is going to ask questions, and you're going to answer them under oath. And these could be, interrogatories would only go to the parties involved in the litigation. Depositions could be more than just the parties. It could be witnesses, other people who have information that is needed for this particular case. You, the paralegal, might be prepping your client or the witnesses for the deposition, how to dress, how to respond, what questions to answer, when to let the attorney step in and make objections. After that deposition is taken, the court reporter will send out copies to the parties of their transcript, and you, the paralegal, may then be tasked with summarizing the deposition and indexing it, so that if the attorney needs to refer to a certain place within the deposition, they can quickly find it based on your indexing. Do they want to go to the question about, where they live, or the question about what medications they took that day? You will have it organized in such a way that the attorney can quickly find the section of the deposition that you're talking about, and you're going to have these prepared, copies of these in a trial notebook, so that once we get to trial, let's say that this particular witness says something different on the stand from what they said at the deposition. Well, that deposition is sworn testimony, and we now can use it to impeach this witness because they have committed perjury. They've said something different on the stand than what they said in their deposition, or what they said in their interrogatories, which is also sworn testimony. So here is the example of the notice that you would send to our client or the opposing side, opposing attorney, about taking a deposition. These are examples of deposition questions, so questions that might be asked at the deposition. And then here you've got that transcript from the deposition, where it's numbered lines with the question and the answer. And then this next document is where you have summarized and indexed the deposition. We're saying that on page 4 in lines 72 through 77. Williams stated that she was on her way to work at the time of the accident. She's about to cross the street. So you are putting it in a format where the attorney can quickly find the information that they need. The next type of discovery tool are requests for production of well, I had something different there. Request for production of a particular piece of evidence, request for a physical exam or a mental exam. Here is where we might say that we want our doctor to examine the plaintiff to see, if we're the defendant, to see if they actually have the injuries that they're proclaiming. If we are dealing with, let's say, a product liability case, we are asking the plaintiff to produce the product that caused the injury so that we can take a look at it. We also might have what are called requests for admission. So we are asking the other party to go ahead and agree that to a certain set of facts so that we don't have to litigate that in trial. Do we agree that the accident happened on June 5th? Okay, if we both do, if we both agree to that, then that's been admitted as a fact. And we don't have to establish that at trial. It's already been established. So the next the next slides are dealing with duties to disclose. So I will stop, and this will be the end of the second video for Chapter 7.